We're ready now to resume our hearing in these trust appeals from the Channel Islands. We're currently hearing submissions on behalf of the respondents in the Guernsey appeal, presented by Mr. Mr. Taub, please.
Please, my lord. I was posed a difficult question by Lord Briggs before the adjournment. A partial answer will come from two authorities I'm about to cite, but the question of overreaching raises really much more difficult issues, and we haven't focused on the position of beneficiaries in this case, because of course this is a wholly insolvent trust, using the sense in which we're using that term here. So we're happy to respond in writing on what's actually quite a tricky issue, but your lordship will see what the Australian authorities suggest about the position of recipient beneficiaries in this situation. Having gone to the Australian principal authorities, we want to pause there and ask, what are the trust law and property consequences of these principles, where the original trustee is removed from office? Assuming the outgoing trustee has undischarged liabilities, which it's facially entitled to discharge out of the trust assets to secure its right of indemnity. There are two possibilities. Either the outgoing trustees may retain assets sufficient to discharge the liabilities. And of course, in this case, the liabilities were hundreds, 140 million at least, and the assets were perhaps only 40 million. The alternative is that the outgoing trustee transfers the trust assets to the new trustee and relies on its preferred beneficial interest in the hands of the new trustee. And I want to contrast the two cases. So take first the case where the outgoing trustee retains legal title possession to the assets. What are the terms on which it holds the assets? We submit it holds the assets in trust to discharge its properly incurred, reasonably incurred liabilities out of the assets. And it can exonerate itself or reimburse itself by self-help. It has no need of the court's assistance. But if it does need the court's assistance, the court can rely on the right of indemnity and seek a court order to give effect to its right of indemnity. Subject to the outgoing trustee's right of indemnity and its preferred beneficial interest, the former trustee holds the assets on a bare trust to transfer them to the new trustee. So if we turn to the position of the new trustee, in circumstances where the old trustee has retained the assets, if the new trustee on a point receives no legal title to assets, what the new trustee acquires is an equitable interest in the assets which are in the hands of the former trustees. And the new trustee's equitable interest in the trust assets is subject to the legal and beneficial interest of the former trustee. So if the former trustee's liabilities are 140 million and the retained assets are worth 40 million, so there's a deficiency of 100 million, that equitable interest of the new trustees is worthless. Now, we submit that it follows from these principles that the former trustees' legal and beneficial interests in the trust assets must have priority over the new trustees' subsequent equitable interest in whatever's left.
Can I just ask you though, Mr. Tauber, Mr. Tauber, on your example, of course, you hadn't given time for the new trustee to incur a few liabilities. But let's say a couple of months later, he has a very big legal bill, and he needs to know in what order of priority whether he can pay anything to his own legal representatives.
We're talking about the new trustee now, who has stepped in circumstances where he's got no assets and he knows that the former trustee is retaining 40 million of assets to cover 140 million. Yes, my lady. Yeah.
Yes, exactly. But you very carefully took us to the definition of trust and trust property this morning. And the Article 32 right of the creditors of both trusteeships are against the trust property.
My lady, yes. And that
doesn't that suggest that, contrary to the usual rule where you would have to define each trustee's interest in the assets separately, that you actually have a pooling under this statute?
Well, with respect, lady, I don't think it follows from that at all, because it doesn't, the Article 32 doesn't address that point at all.
Well, it gives the creditors, both sets of creditors, a right out of the trust property, which is the entirety of the trust property.
It can't mean literally that a trust creditor has got a right out of the trust property in all circumstances. I mean, take the case of a trust asset which is the subject of a charge to a bank. So it can't mean the unencumbered value of the trust assets. So, in my respectful submission, one gets no answer to this question from Article 32. It involves, one has to go back, I would suggest, to first principles rather than try to find an answer from Article 32, which just doesn't address this.
Well, surely it's a matter of statutory interpretation.
Yes, and if the statute doesn't say anything to assist you on that, in my respectful submission, it doesn't provide the answer.
Well, the statute gives the creditors the right against the trust property.
Well, that respectfully, is a phrase which is ambiguous.
Is it? Because it's a defined term. Anyway, we'll come to it.
Yeah. And in any event, my lord, it's. I'll come.
Mr. Torp, sorry, Mr. Torp. Sorry to interrupt you again, but can I just ask one question to clarify what you've just been saying to the board? The question of whether there is priority in favour of trustee 1 over trustee 2 in the sort of circumstances you described. Am I right that on your argument it has to depend on them each having an equity of some kind, and the court giving the equity of the first trustee priority over that of the second?
No, there are two aspects of the argument, my lord. The first aspect is that the former trustee has a right to self-help. If he's got the assets vested in him, he can simply discharge the debts to which he is subject.
Well, this is, if I can just jump in quickly, this is what slightly puzzled me. I mean, yes, that's right, but when he is helping, he's discharging what's owed him out of the trust assets, is he not on the authorities doing that by virtue of his right of reimbursement, which is secured by, I use that in a neutral way, by the equity that he's given? I mean, the fact that he also holds the legal ownership may be just fortuitous in these cases, depending on example to example. I mean, he may have transferred them, he may not have transferred.
I'm going to contrast the two. In my respectful submission, it's not fortuitous if the trustee, former trustee, has retained the assets
so that
as security.
The answer to my question then is it that if he's still got legal title, that of itself, regardless of how the equities stand, gives him some sort of priority, a right to take 100% out of what's available?
My lord, yes. On the facts of this case, the answer is yes, and one can test that proposition in the following way. Let us imagine that the trustee discharged the assets of, sorry, used the 40 million of assets to discharge the liabilities of 140 million, let us say by some sort of composition or agreement with the creditors. In those circumstances, neither the beneficiaries nor the new trustee could complain. There's no breach of trust, no breach of duty by the former trustees to the new trustees in that situation. There's no prejudice to the new trustees' equitable right of indemnity out of what's vested in him, because it's worthless. It has no value. The right of indemnity is a right of indemnity out of what's vested in you as a trustee. So in those circumstances, there's been no prejudice to the new trustee by the former trustee exercising the right of self-help. That's the first point. Can I develop it further? The second point is this. Let's imagine. Let's take an example. Let's imagine that the former trustees held a fund of 10 million of assets, and they were subject to a trust creditor's liability of 5 million. And they set aside some land worth 5 million to sell to realise. And before they could realise that 5 million of land, Mr. Jenkins had come along, exercised his power, and removed them as trustees. And the trustees would say, right, we're going to retain that 5 million worth of land, which we're in the process of selling, and we're handing over the rest of the assets to the new trustees. And let's imagine further that before the former trustees can sell the land, at the request of the beneficiaries, the new trustees invest in derivatives. They have a margin account, the derivatives collapse in value, and their bankers say, we need another 10 million of security for your derivatives trading. All done at the request of the beneficiaries, so not a breach of trust. And the new trustees incur a liability of 10 million pounds. They lose all their investments. They then come along to the former trustees and say, we have got a liability for 10 million pounds, which we incurred in full knowledge of the fact that you former trustees will retain 5 million specific assets. But we claim that the proceeds of the sale of the 5 million value land has to be shared with the new trustees to discharge their 10 million debt. So in those circumstances, the former trustees are presented with the claim by the new trustees that they can't discharge the 5 million trust liability that they had. They can only discharge 1/3. Now, well, we respectfully submit that it cannot be right that where trustees, former trustees, have set aside assets, retained them for the purpose of discharging liabilities in that way, that the new trustees can come along and incur new liabilities and say, aha, we're going to share in the property which you've set aside. So one has to ask, why would the new trustees have a claim in breach of trust or a claim of any other sort of breach of duty against the former trustees for exercising their right of self-help and implying the whole 5 million in discharge of their existing liability? That is what I respectfully submit lies at the heart of the issue here.
Well, I don't know whether it would be a breach of trust, but as between trustees, but I mean, normally trust duties are owed to beneficiaries, not to other trustees. But the but wouldn't the second trustee, if once it became clear that the trust assets overall were insufficient to make all existing trustee, to meet all existing trustee claims, be able to go to the court and say, look, you need to decide whether in the event of this shortfall, the first trustee can simply utilize the trust assets it's retained in specie to meet its claim, even if that gives it more than a proportion of the available assets, or that there's some other basis of distribution, whatever it may be, by determining how the equities lie.
With respect, well, that's begging the question.
Well,
of course, in practice, one quite understand why in practice the new trustee might go to the court and ask that question. But the ultimate test here, in my submission, is would it be, would the new trustee have a cause of action if the former trustee exercised its right of self-help and used the proceeds of the 5 million land and discharged the debts to its creditor? Lady Rose, I'm sorry.
What would happen in your example if before the trustee who's held on to the land sells the land, the trustee before him comes along and says, oh, I've now just been sued by somebody for £10 million for something I did whilst I was a trustee, and I might have to pay out to him. So you can't sell that land that you've held on to, because I would have held on to the land if I'd known about this, but I didn't know about it. So who has priority then?
That raises the question, the next question of equitable priorities, my lady, and I'm coming on to that, but that depends in our submission on a different question, which is if the original trustee has incurred the liability properly, prima facie he's first in time. Prima facie he would be entitled to priority. But as with all cases of equitable interests, where they rank ordinarily according to time, the question would arise whether there had been inequitable behaviour on the part of the first trustee, which had led the second trustee to incur liabilities without knowing anything about, putting it very crudely. It's what in Australia has been called disentitling conduct by the holder of a prior equitable interest. So in your ladyship's example, which I was going to come on to when I'm dealing with priorities, the point is this: first in time ordinarily prevails. But if the holder of the prior equitable interest has done something which might, for example, have led the second trustee to incur the subsequent liability in complete ignorance, perhaps there'd been non-disclosure or negligence. Ordinarily, when there's a handover from trustee 1 to trustee 2, there's a requirement to provide accounts and full disclosure. Imagine that the first trustee had failed to make full disclosure. Now, in Australia, that would be characterised as disentitling conduct, inequitable behaviour, and that would prevent the person with the first equitable interest in time asserting priority over the second trustee in my lady's example. Does that answer your ladyship's question? I hope that does. Can I just
I mean, assume none of that on my lady's question. Assume that the prior trustee had been a director of a company owned by the trust. There's nothing to disclose, but by virtue of later events, some liability comes in. or there had been full disclosure of everything that could reasonably be known. As I understand it, your answer is the first trustee would take priority over the subsequent trustee, even though the subsequent trustee has legal title to 5 million worth of land.
That would be my answer. Yes, because of the well, sorry. Can I just think? There is a wrinkle, of course, because when the question is priorities between an equitable owner, first equitable owner, but there's a second legal owner, then one has to, there are circumstances in which the second legal owner can actually get priority. It's dealt with in, if one looks at the bundle, I'm afraid in McGarry and Wade, there are circumstances in which the holder of the legal title can get priority over someone with a prior equitable interest. And the treatment, the best treatment one gets is in the context of mortgages, where one has first equitable mortgage and the second legal mortgage. In the bundles, in McGarry, we've included McGarry and Wade's Law of Real Property, which contains a consideration of that issue. I was dealing with, I must confess, I'm grateful to my to Sir David's intervention. But lady, I was dealing with a position on the footing there were two equitable interests, but there is a possibility that where you have an equitable interest followed by a legal interest, then the legal interest can prevail, and one finds that dealt with, as I say, in McGarry and Wade's Law of Real Property. It's chapter 25 of the new edition. If you want the reference in the bundle, it's at Guernsey bundle 4931. And in fact, on the question of priorities, that's probably the best treatment that I found since writing the case on the question of priorities between legal and equitable. So that, oh, sorry, my lord, yes, my lord Briggs, yes.
Would it be an unfair summary, I haven't yet read it, of those provisions to say that the subsequent acquirer of legal title would only take free of the prior equitable interest if he was equity's darling?
I think that's right.
I.e.,
yes.
a bona fide purchaser of a legal title without notice. Yes, but a subsequent trustee can hardly take without notice of the entitlement of a prior trustee.
Well, again, ordinarily that's right, but there are circumstances in which he might. And he might also do it for he might, for example, take on a trusteeship for consideration. But yes, my lord, that's how I accept it.
But you seem to be saying, Mr. Torp, that if legal title gives you some extra right, in the example we've just been discussing where T2 now has the legal title, that would enable him to trump the equitable rights of T1.
It might in the example Lord Briggs has just given. I think that the chances of him being a equity's darling may be limited. I think.
Well, it wouldn't matter because on your argument, of course, he'd take subject to the equities. He'd take subject. He wouldn't take free of it. But your argument, if I understood it, I mean, wherever the legal estate is, it gives you some superior right over a trustee who doesn't have legal title, but merely an equitable right of reimbursement.
No, my lord, I don't think I'm going quite as far as that. What I'm saying is,
why does it work one way and not the other?
In relation to the case with which we're concerned, where we've got basically the original trustees, we didn't have prior trustees. There was no interest of prior trustees to consider. We had an interest which took priority over the beneficiaries. Therefore, there was nothing standing in the way of the former trustees exercising their rights of self-help. Those rights were simply rights which they had as legal owners, and under Article 26 of the Trust Jersey law. The difference between the former trustees and the new trustees who take subject to the former trustees' interests is there is nothing that the new trustees can complain about as a breach of duty in the example that I've given. And that is the reason why we say it makes all the difference.
But T1 on my example would take subject to T2's equity, where T1 was no longer a trustee but still had legal title. That legal title would be subject to the equity that would have arisen in favour of T2 on T2's appointment.
Well, the question is, what is the nature of T2's equity? If T1 has retained all the assets worth 40 million to discharge liabilities of 140 million, all that T2 acquires in such circumstances is an equitable interest that if by some magic the trust turns out not to be insolvent, there will be a duty on the part of the T1 to transfer the surplus to him. That's the equity. The right of the new trustee to be indemnified is out of the property which is vested in him.
I thought that your submission was that there was an equitable beneficial interest which arose as a result of an office, had nothing whatsoever to do with physical possession or with legal title.
Yeah.
The legal title was a method by which you could enforce that right, but it didn't give you a priority. The priority came, I thought, on your argument, on the basis of first in time of the creation of the equitable right, so that one ignores the legal title in relation to the creation of it, and one ignores it in relation to priority.
My lord, I apologise for the confusion. I'm at this stage dealing with the alternative argument. Your lordship, if I may say so, has summarised succinctly the argument which prevailed before the Court of Appeal and which we seek to uphold. But if you recall, I was also had an alternative submission, which is based on the fact that possession and legal title was retained by the former trustee. And so the submissions which I've been tested on just now are primarily related to that alternative submission.
Mr. Thorpe, can you point to any authority that says that where a trustee who continues to hold legal title to the trust assets, as you put it, helps himself out of the trust fund to meet its indemnity, he's exercising some separate right as legal owner, rather than giving effect as trustee to his own prior beneficial right to have his expenses paid ahead of the beneficiaries?
I can point to no authority, and I'm approaching it on the basis of first principle.
I see, thank you.
And I want to make that absolutely clear. If there was authority, I would show it to your lordship. But this is where the question of the relationship between law and equity actually becomes quite challenging, because to say that as trustee one has a right against oneself doesn't make any sense. So one has, as was pointed out in the Amarind case in the passage in 80 to 84, that the legal title is in the trustee, but one has to look at the obligations imposed on him. And the obligations imposed on him are primarily obligations to the beneficiaries. When he retains the legal title to the assets that he requires to discharge the debts, then we say he doesn't have a right against himself. He's just entitled to exercise the rights attached to legal ownership. And no one has, he owes no duty to anyone which is prior to his own rights. That, in substance, is the alternative argument, if I can put it that way. Obviously, I really do need to focus on the argument which came before, which prevailed in the Court of Appeal. Could I make one point on the alternative argument?
Can I just ask, is what you're arguing for something akin to an old-fashioned legal mortgage?
I'm afraid I didn't catch what you said.
Sorry. Is what you're arguing for something akin to an old-fashioned legal mortgage, where the legal title is vested in the mortgagee?
Well, there was I hadn't thought of the analogy, but I see what you're saying.
Aren't you saying that the first trustee is in the same position as if he had transferred your 5 million worth of land to the second trustee, subject to a legal charge securing his indemnity?
No, because he's never transferred the 5 million.
No, I'm saying as if he had. So aren't you saying, I mean, if the first trustee said to the second trustee, I've got this 5 million liability, I will transfer Blackacre to you, but only subject to a legal charge in my favour for that liability. Wouldn't that put him in the same position as if he hadn't transferred legal title at all?
Oh, I see I'm sorry, I misunderstood the point. That would produce the same result, yes.
Yes, but in your case, the first trustee has retained legal title, and he's in the same position, isn't he, as I say, the old-fashioned legal mortgage.
I'm sorry.
He's got the legal title.
I haven't followed the analogy, and I apologise. And if I may, I'll try and come back to it. But I've got 20 minutes to cover what's the issue in this case. Just finishing on that analysis, could I point out that the Royal Court of Guernsey, in the judgment of Lieutenant Bailiff Chad, which you'll find at 1953 in the bundle, said this is precisely what we could do. So, one finds it at, I'm so sorry, I thought they were given the wrong reference. It's at 3313 of the authorities in the Guernsey bundle. In Guernsey 1, the new trustees complain about the retention of the assets by the former trustees. They said there was no right of indemnity, and they insisted on the assets being revested in the, or rather the assets being vested in the new trustees. At 3313, one finds the holdings of the bailiff, which on this subject has never been clear. He said, I hold that the former trustees may retain and realise such of the assets subject to the trusts of the TDT as remain vested in order to satisfy their obligations as borrowers in respect of the Glenalla, Thorson an Oscar-Tello arrangement. Well, there was an appeal against the Oscar-Tello, but what Lieutenant Bailiff therefore decided was that the trustees were entitled to retain and realise the assets and apply them in discharge of their liabilities. And that was in circumstances where it was quite clear that the successor trustees had been in office, long time, incurred liabilities. And so there's never been an appeal on this aspect of the judgment of Lieutenant Bailiff Chapman. There was challenge to the fact that the rights of indemnity were not properly incurred, and that challenge was unsuccessful in front of Investec, in Investec 1 in front of the board. The panel will see that this question has actually been determined and there's been no appeal against it. And that's why we do say that the right of self-help in this case was exercisable in this way, and it's not open to Mr. Matron's clients to challenge that. And so that completes the analysis so far as of the two alternatives. One, the retention by the trustees of the assets. As Lord Stevens has pointed out, that leaves open the possibility in any event, if you disregard my self-help argument, that the former trustees had an equitable preferred interest which ranked prior in time. And so we have to come on to the question of priorities of competing interests in the same property. But can I, before getting there, just make a couple of points which deal with the appellant's argument that the rights of the former trustees, when they transferred the assets, don't bind the trust assets. There are at least 3 cases on Australia which hold that they do, where it's a matter of decision. The first is a case called Rothmore Farms, and the court will find that, no time to go to it, but it's in Guernsey Bundle 4501. The story was this, and it's relevant to Lord Briggs's question for the adjournment. The court held that where Trustee 1 transferred assets to Trustee 2, and Trustee 1 had unpaid liabilities to its bank, Trustee 1's proprietary rights in the assets survived against the assets. And the liquidator of Trustee 1 was entitled to enforce Trustee 1's rights of indemnity out of the assets against a succession of people into whose hands the assets came. First, Trustee 2, Belgravia, and later there was a distribution to a beneficiary by Trustee 2. And the Australian court held, it's not High Court of Australia's first instance decision, held that the first trustee's rights against the asset survived when the property is in hands both of Trustee 2 and later a beneficiary. The second case is Lemery, which my learned friend Miss Jordan has already referred to. And the third is Augusta, where my learned friend Miss Jordan has referred you to a couple of the statements of principle. But it was in that case a matter of decision that the former trustee's preferred beneficial interest survived in the following circumstances. Augusta was trustee of a unit trust, and incurred a judgment debt to Provident. Subsequently, Augusta was replaced by trustee 2 called Reaver, and Augusta transferred the trust assets to Reaver without any agreement for covenants of indemnity. And Provident claimed that Augusta had alienated the trust assets with intent to defraud creditors. And the Court of Appeal of New South Wales rejected Provident's claim. And you've already seen the statements of principle dealing with the rights of the former trustee binding the property. The authorities at Guernsey Bundle 1983, and I would like to take the court to paragraphs 83 and 84. Which are 2013 of the Guernsey Bundle, 2013 of the Guernsey Bundle. And the New South Wales Court of Appeal summarised what was a very careful consideration of the rights of trustees, successive trustees. And they said the alienation by, this is 83, in summary, the alienation by the first trustee, Augusta, to Reaver did not alter the steps that Provident, the creditor of Augusta, could effectively have taken to enforce against the King's Park land, the trust property, the money judgment it had obtained against Augusta. Both before and after the alienation, execution at law was not open to trust creditors, but they were entitled to assert Augusta's preferred beneficial interest, and thereby to obtain equitable execution through the sale of trust property by a receiver appointed by the court. The fact that Augusta's preferred beneficial interest and the creditor's right of subrogation in relation to it subsisted in the trust assets after they became invested in the new trustee meant that it was not incumbent upon Augusta to obtain from the second trustee, Reaver, any particular undertaking to protect those creditors. The trust assets, when received by the new trustee, continued to have imposed upon them the entitlements derived by creditors from the former trustee's preferred beneficial interest, and this was so whether or not any such undertaking was sought or given by the new trustees. Then going over the page, it was said, first instance, there was the risk that the second trustee could sell the land to an arm's length purchaser and distribute the net proceeds to trust beneficiaries without satisfying Provident's judgment debt. The Court of Appeal rejected that, saying such action by Reaver, assuming that distribution would have been required by beneficiaries, would have entailed impermissible disregard of the beneficial interest in trust assets, to which trust creditors were entitled by subrogation from Augusta, being an interest that took priority over the interests of beneficiaries and continued to subsist in trust property following the transfer to Reaver as new trustee. Equity would have given full effect to that preferred beneficial interest. So, my Lord, Briggs, that doesn't deal fully with your Lordship's question.
No, but doesn't it fall critically short?
I'm sorry.
Doesn't it fall critically short of saying, and what's more, T1's interest had priority to any similar interest of T2?
My Lord, yes. I don't say that it says that. I'm not saying that's the analysis. I'm drawing it to your Lordship's attention that it's a case where, as a matter of decision, the New South Wales Court of Appeal has decided that it bound the interest in the new trustee's hands. So with that really is the stepping stone onto the next issue, which is question of priorities.
Yeah.
So before you continue, I'm very conscious of the fact that you, the respondents, have lost an hour today in their time, and you're having to deal with some really very complex issues under a degree of time pressure which was never intended. I was wondering what the best way is of dealing with this. We could allow you additional time this afternoon and shorten the time for replies, but allow them to be supplemented in writing. Or we could keep you to your time, but allow you to put in further submissions in writing. It's really, I'd be grateful to know what you would feel would be the fairest way for us to deal with you.
Well, I would like an opportunity to say something orally about the principal issue in this case, which Ms. Jordan is looking to me to make submissions on behalf of both parties. And I think it's only fair that the panel should have an opportunity to quiz me about those submissions. So if I may expect...
Well, in that case, you take further time to the extent you feel you need it, and we can, to the extent that that may mean that time is shortened for replies, we can allow submissions to be made in reply in writing. I see that Ms. Warnock-Smith would like to contribute. Yes, Ms. Warnock-Smith.
45 minutes. It's a short enough period to make a reply. Under your proposed plan, how long would you suggest we would have today? I think we would be happy with the idea of supplementing what we are able to say this afternoon in writing, because there is quite a lot to cover. But I would like the opportunity this afternoon to say at least a little bit about pulling the strings together.
Yeah. Well, and Mr. Mitchell may be in the same position. If we were to allow Mr. Torp to continue until 3:30 and give you half an hour for your replies, how does that strike you?
Half an hour between us.
Yes. Supplemented in writing if need be.
Yes, yes. It's not Mr. Mitchell and we have not exactly been ad idem about sharing time, but I'm sure we can hammer out some sort of agreement.
My lord, if I'm squeezed into writing largely, then so be it.
Yes. Yes, I mean, the nature of things, I think replies are probably the submissions that lose least from being given in writing. Whereas I think we really do need to, Mr. Targ does need an opportunity to be able to develop his submissions before us and be questioned by us, I think. So, Mr. Torp, shall we proceed then on the basis that that you can carry on until 3:30?
I'm very grateful to the panel and to my opponents. Thank you.
Right.
To return to the nub of the issues, finally, and the board will be aware that the well-established principle in dealing with competing equitable interests in the same property is that the first in time applies to the ranking those competing interests. And the lower courts in Guernsey and Jersey have held that those ranking rules apply. And the principle is stated in Senac and Schaeffer very economically, cited in our written case. The general principle where competing equitable interests are in play is that where the equities are equal, the earlier in time prevails. And the former trustees submit that represents what the law recognises to be the fair and just result as between persons with competing equitable interests in the property. And the lower courts were correct to apply the rule in this case because the respective rights of the successive trustees to indemnity were equitable rights of a proprietary character in the same property. And the equitable rule is one which is generally applicable, suggested by my learned friend Mr. Machel that there are exceptions, but as I will show, that the suggested exceptions of mixed funds and solicitors' liens are not cases which would otherwise fall within the rule anyway. They're not truly cases where the rule is applicable. And Mr. Machel, in his written case, accepted that the first-in-time rule is the ordinary rule which applies to rank beneficial interests that are competing in the same property. But he says that the interests of the successive trustees are not competing, and that they're sui generis, and that it would be fair and just to adopt a pari passu approach in the present case. And the respondents, both sets of respondents, submit that the interests of successive trustees are competing interests, where the trust's assets are manifestly insufficient to meet the outgoing trustees' liabilities when they're removed as trustee, as this case graphically illustrates. It couldn't be a clearer case that there is if my learned friend is right, then there is a competition here, because he says the new trustees could go and incur liabilities willy-nilly when they had no assets in their hands, and compete with the former trustees' retained fund and right of indemnity out of that fund. And we submit this is a clear case of competing. Secondly, we say that the rights of indemnity of trustees and the equitable proprietary rights generated by them, whilst they're not identical to other equitable interests, the same fundamental proprietary character to which the first-in-time rule applies, nevertheless, they are sufficiently similar to fall within the rule and the policy that underlies it. And thirdly, we say that adopting a pari passu rule would, in fact, as the facts of this case graphically illustrate, be unjust and unfair, and be wrong as a matter of policy and principle. Now, we do need to look at the sorts of situations in which the rule has applied to understand why we say that this is the sort of case where the rule applies. And I can do this best, if I may, by asking you to go to our written case, which summarizes the sorts of situations in which the rule has applied, and that's at Guernsey Bundle 108. It's section E of our written case. And we've attempted to summarize the situations and the types of interest to which the first-in-time rule applies. And at 108, we set out textbook authority for the proposition. We cite the passage in Macmillan, which the panel has already seen. And then over the page 109, at paragraph 95.3, we note Seneca and Schaffer. That was a case of competing claims by successive purchasers of land, effectively. And the first-in-time rule applied. The rule applies to beneficial interests under trusts, the same way as other equitable interests. One sees that from the Shropshire Union case. And if one goes to the Guernsey Bundle at 4586, one finds the case, and at 4596, one finds the rationale of them given by the Lord Chancellor. And this is a principle which has been applied time out of mind. It's applied Abigail and Lappin. It's applied in the modern Australian authorities. Bottom of 560 internal pages, the Chancellor says in the final paragraph, your lordships have to deal with a case of pre-existing and undoubted equitable title, and circumstances which are alleged to have defeated and have taken away the pre-existing equitable title. My lords, that pre-existing equitable title may be defeated by a supervening legal title obtained by trance. And I agree with what's been contended, that it may also be defeated by conduct, by representations, by misstatements of a character that would operate and inure, to forfeit and take away the pre-existing equitable title. But I conceive it to be clear and undoubted law, and law the enforcement of which is required for the safety of mankind, that in order to take away any pre-existing admitted equitable title, that which is relied upon for such a purpose must be shown and proved by those upon whom the burden to show and prove it lies, and that it must amount to something tangible and distinct, something which can have the grave and strong effect to accomplish the purpose which it is said to have been produced. So that is said to be that's the underlying policy which has been applied in these cases. If the holder of the second equitable proprietary interest wishes to get priority over the first holder's interest, that he has to show that there's some, in essence, inequitable conduct, inequitable behaviour, or as it's been described in Australia, disentitling conduct. And I mentioned a short while ago that these propositions apply to equitable mortgages and priorities in equitable mortgages, subject only to the operation of the rule in Durl and Hall, which I will consider in a moment. And the best treatment that we have found of that is in the Chapter 25 McGarry wage, which I've already referred to the panel. But my learned friend suggested that the rule in Durl and Hall was somehow an exception to the rule. The panel will recall that where you have funds vested in a trustee and there are successive dealings in the equitable interests by the holders of the equitable interests, the holder of the first interest may lose priority if he has failed to give notice to the trustee before the second equitable beneficial title. But that, we submit, is really just an example of a form of disentitling conduct on the part of the first holder of the equitable interest. He has failed to take an elementary precaution to protect himself by giving notice to the first trustees of his first equitable interest. And we've set out at paragraph 96 the basic principles that the priority rule can yield to in a case where the holder of the first interest has been guilty of disentitling conduct or inequitable behaviour. And one finds statements of the principles in Snell, and the Privy Council decision in Abigail and Lapp is worth noting. The opinion of the Vice-Chancellor, that was reference to an authority called Rice and Rice, no doubt has not been approved insofar as he says that priority in time is only taken as the test where the equities are otherwise equal. It is now clearly established that prima facie priority in time will decide the matter unless that which is relied on to take away the pre-existing equitable title can be shown to be something tangible and distinct, having grave and strong effects to accomplish the purpose. And
sorry, Mr. Tall, where are you reading from?
I'm reading from paragraph 109, sorry,
well, which
109,
page?
110 of the Guernsey bundle, which is my written case. I've summarised the authority.
Oh, I see. Right.
And Abigail and Lapid is in the bundle of authorities, but that's the statement of principle.
Yes, thank you.
I'm sorry. So, the question then is there a reason to depart from the ordinary equitable rule? And linked to that question, obviously, is this a case which ought to fall within the ordinary equity? And we say, yes, it is, because there are clearly competing equitable proprietary rights being claimed by former trustees and the current trustees in the same assets. And they are, to use the example given yesterday in discussion, they're analogous to rights which are enforceable by the court under a contract for specific performance. From the fact that the court will order a specific performance of a contract purchased on behalf of the purchaser gives him an equitable proprietary interest in the property, even if he hasn't got a legal. Similarly, the right of indemnity here generates an equitable interest which the court will enforce. Now, my learned friend says that the court is somehow free to fashion its own scheme because it has done so in other sorts of cases. And we respectfully submit that the cases in which to which he refers simply aren't cases to which the prime facie first in time rule is applicable at all. So he gives three examples. He gives the example of a solicitor's lien. He gives the example of cases involving mixed funds. And he gives the example of statutory schemes on insolvency, dealing with the rights of unsecured creditors. Now, none of those cases truly involve the ranking of competing equitable proprietary interests in the same property. So none would fall within the first in time rule anyway. I mean, let's take the solicitor's lien case. As was pointed out in this case, the solicitor acting for the client in litigation at the time when the fruits of litigation are recovered would take priority over the client's previous solicitor. But it's being pointed out that the priority is given to the second solicitor because the charge, the proprietary interest, really only becomes effective when the fund has been recovered. So at the time the first solicitor acts, there's no fund over which the proprietary interest could exist. So it's not a case for application of the first in time rule at all. The second analogy is the case of mixed cases of investors' money. And again, the problem, we say, this is not a case where the first in time rule is capable of having any application. The problem in the mixed fund cases, the Barlow-Clowes case or any other case of that kind, where there have been thousands of investors paying over to a company into a mixed account, and then the funds largely disappeared. You can't trace the property of an individual investor. So there's no scope for the first in time rule to apply. There are examples in the cases where actually it is possible to trace the money of an individual investor in that account. The classic example is where a freezing injunction is obtained on day 25 of the scheme and someone pays in the money on day 26. And prior to his payment in, the fund was standing at nil. And then you can see that the money that's gone into the fund must have been that last payer's contribution. And in those circumstances, pari passu doesn't apply. And you see that from the head note of the case called Karan and Jahani, which is a New South Wales case. It's at Guernsey bundle 2860. And the same principle has been applied in a case called Russell, Cook and Prentice in this country. The head note doesn't show it, but if one looks at GB Guernsey bundle 4562, paragraph 40, one will see that although pari passu applied to most of the funds, because one couldn't tell where they had come from, where one could tell where the funds had come from, and that an investor had a proprietary interest, then that was respected. So in our submission, the mixed fund analogy is of no use whatsoever. And similarly, the reliance on statutory schemes to regulate the distribution of state of bankrupts and insolvent companies is not dealing with the current issue at all. The statutory pari passu rule on bankruptcy applies only to unsecured creditors. And if a creditor has security over an asset bankrupt, it's not included within the property available for distribution amongst unsecured creditors, subject to any issues about preferences. And by contrast, in the case of a former trustee's right of indemnity, the former trustee has an equitable interest of a proprietary character in the trust assets. So it's not analogous to the position of an unsecured creditor of a bank. And so the other point the learned friend, Mr. Machel, sought to pray in aid was the position of trust creditors. There might be thousands of trust creditors, and their claims, it's a fair solution to them is to deal with the position pari passu. But with respect, that ignores the way in which a trust creditor, that's to say a creditor of an individual trustee, gets access to the funds. That creditor has no direct claims to the funds, can only make a claim against the fund through a claim to be subrogated the right of the trustee with whom the creditor contracts. So the question really comes back to who has got priority as between the trustee's rights of indemnity. And when one thinks about the position of trust creditors, of course, they are not necessarily going to be treated pari passu in any case. Let's take the example of a trust where there have been two successive trustees, trustee 1 and trustee 2. Trustee 1 has creditors whose claims have not yet been satisfied. Trustee 2 has claimed the creditors have not yet been satisfied. If trustee 1 has no liability to account, then obviously trustee 1's creditors can claim against the fund through trustee 1. But if trustee 2 has committed a breach of trust and is liable to account, for that breach of trust, whether it's to the beneficiaries or to the first trustee. And there's a liability account which hasn't been satisfied. Trustee 2 does not have a presently enforceable right of indemnity exercisable at that date. So if, for example, Trustee 2 creditors have lent £1 million to Trustee 2, and Trustee 2 is liable for breach of trust for £2 million, Trustee 2 creditors have no claims through subrogation. So the scheme of trust creditors going against a trust fund where it's insolvent does not lead to the inevitable conclusion that trust creditors are going to share pari passu on any basis, even if your the panel were to decide that the claims of Trustee 1 and Trustee 2 should rank equally. It doesn't follow automatically that the creditors of Trustee 2 and the creditors of Trustee 1 will be treated pari passu.
But do you accept that as between themselves, the creditors of Trustee 1 rank pari passu in the exercise by subrogation of an insufficient Trustee 1 indemnity, by which I mean insufficient to pay them all?
My lord, that's an unresolved question, but I think I mentioned in answer to a question from Lady Rose this morning, that's what the first instance judge in the present case did, but so to speak, debini esse, saying that if someone wished to challenge it, they could come in and do so.
Well, what's your submission on it?
Well, it is. I mean, it isn't a direct impact on me, but
I know. Well, don't worry now, but I would like to know what it was.
Can we give you something in writing?
Yes.
As I say, we don't have any trust creditors. As you know.
And I know you're under time pressure.
So that leads to the question, well, is there some overriding equitable reason why the court should ignore the first in time equitable and say that the successive trustees' interest should rank pari passu? And we respectfully submit that the policy arguments that are found in the judgment of Justice of Appeal Logan Martin in the Z Trust case were absolutely correct, spot on. And we also adopt what Ms. Jordan's written case says at paragraphs 88 to 1994, which you mentioned this morning, which deal with the policy issues. But in a word, where a new trustee takes on a trusteeship, knowing that the assets are being retained in their entirety by former trustees, they have a duty, obviously, of due diligence to find out what's gone on. They can make the decision whether or not to accept the trusteeship. No one's obliged to accept a trusteeship. And as we point out in our written case, it is an elementary principle of self-protection for a prospective new trustee to obtain detail, to ask questions about what's going on, and to make an informed decision based on full disclosure from the old trustees. And the position is that those sorts of inquiries will entitle the new trustee, if it accepts appointment, to costs. So it's a proper thing for them to do. And we therefore contrast the position between the prospective successor trustees who don't have to take on trusteeship. And indeed, if one looks at the facts of this case, it is quite extraordinary that anyone should take on the trusteeship in this case, when there were no assets which were going to be transferred to the successors to Investec and Bio, when it was clear that the liabilities hugely exceeded the assets, and where litigation was on foot. And one has to contrast the position of successor trustees, who, or prospective successor trustees who've got a choice, and the position of former trustees, who, if they hand over assets to the trust fund, lose all control over what happens, and find themselves in a position where they have no, there can be no security for them, absent covenants or prior, or absent their beneficial interest taking priority. They have lost control of the assets, they have no idea what's going to go on, and they are at the mercy of the new trustees. And it's for those reasons, among others, that Justice Logan Martin came to the conclusion that it was right to insist that the former trustees' rights took priority. And one's got to think of it not just in the Guernsey, Jersey context. One's got to remember that all over the world there are provisions in trust legislation which allow a person with the power of appointing new trustees to remove trustees against their will and to vest the trust, and the mere act of taking that step will vest the trust assets in the new trustees. That's the effect of section 40, subsection 1b of the English Trustee Act. It's the effect of many of the Australian provisions. And so, take this example. Let's imagine that someone has lost, a trustee has lost capacity and is removed. He's not in a position to negotiate for new covenants of indemnity. The assets automatically vest in the new trustees. And that person may have incurred liabilities which haven't been discharged, has been unable to exercise a right of retainer. And the implications of my learned friend's suggestions is in the English context, the preferred beneficial interest that the former trustee who's been removed, first they say disappear with a puff of smoke. That's the Guernsey Appellants argument. Secondly, they say that the new trustees can do what they like with the assets, provided the beneficiary's consent, because in those circumstances, the beneficiary's consent, there won't be a breach of trust. And then say to the estate of the incapable former trustee, or the removed former trustee, or the trustee who's outside the jurisdiction for more than a year, you can't discharge your liabilities in priority to us. You've got to accept that the new trustee, with the beneficiary's approval, can incur liabilities to his heart's content and claim pari passu. That's what the case amounts to from a learned friends in this case. And we respectfully submit that as a matter of policy, it can't be right to allow the successor trustees' claims to rank pari passu with the new trustees.
But what do you say, Mr. Todd, to Mr. Mitchell's point that the subsequent liabilities incurred by the second trustee have all got to be properly incurred. I mean, you painted all these horror stories, but I mean, they've still got to be proper trust liabilities, haven't they?
My lord, they do, but the way the case is being run is that if the beneficiaries consent, then it's a proper expenditure. That's the first point. It's been suggested that take the example of the litigation expenses of the successor trustees in this case.
Yeah.
So they litigated against the former trustees for years, trying to deny their right of indemnity. But whenever challenged, they said, "Oh, we've got a better award," which was in proceedings between the beneficiaries and the successor trustees. And they said, so it must be a proper expenditure. But they never joined the former trustees to those better proceedings. And yet they say, oh, well, it flows from Article 26 that our liabilities are all proper. And therefore, we're entitled to discharge them out of the trust assets, pari passu, with the costs of the former trustees who were successful. That is what the argument is in this case. And my respectful submission, that does not achieve fairness or justice. And the pari passu rule ignores that the new trustee comes in with knowledge, in this case, of all the liabilities that are there, all prospective liabilities, the liabilities to BVI companies and the liabilities in the litigation. And what's being said is they can just ignore the fact that they've already been incurred and are likely to continue being incurred and claim pari passu in opposing. That's what it comes down to. I've got to 3:30. I think I've dealt, and I'm afraid I have been very rushed. And if there are further questions, I'm happy to deal with them. But my Lord Stephens.
Just going back to Lord Briggs's point, that is the creditors of Trustee 1. You're not suggesting that they have any equitable interest in the trust property. Therefore, they have no equitable rights. They have to be ranked first in time. And wouldn't therefore pari passu apply as between those creditors? They're right, as between themselves. The equitable right is the equitable right of the trustee by virtue of his office. The creditors have no equitable right in the trust fund except under subrogation to the Trustee 1. Yes. And so their rights should therefore rank pari passu. Because there wouldn't be
between the trust creditors. That may well be right. My lord, I'm not sort of cavilling. It's just because I haven't had to consider the issue because it doesn't arise in my case. I just haven't thought it through, and I apologise. But it's
yeah. Okay.
Did you wish to say anything more about Section 32?
Article 32 of the trust.
Forgive me.
Sorry, that's a pedantic point, but I just
no, it's not. It's quite right. Article 32, which provides this scheme whereby the trustee has no personal liability, but the creditor of the trustee will come in and be able to prove against the trust property. So if you get,
could I look at the? Could I?
Well, you're very kind. You may want to deal with this in writing because I do.
Your Ladyship, I think I would like to because I haven't.
Well, I'm most grateful. If my Lord, the President permits it, I would be most grateful.
Could I do that, please? Then.
Yes, yes, certainly.
My lords, I have come to the end of my time, and I don't think it's fair that I trespass on the respondents.
Yeah.
I'm grateful to the opportunity to put something in writing. And if I can help further with Lord Briggs's question for adjournment, would you like assistance on that too in the written submission?
Yes, I think so. Obviously, you've provided us with a substantial written case, which we will consider very carefully. But if there are matters that you feel are not adequately dealt with in your case, and which you would have developed further in your oral submissions if you had had time to do so, then by all means do that in writing now, and you could deal with Lord Briggs's question in the course of doing that.
I think the questions of Lord Briggs and the questions that have been posed about trust creditors ranking pari passu into say, and Lady Alden's question probably are best dealt with in writing.
Yes.
Yes.
Just so you understand, Mr. Torp, the reason I ask the overreaching question is that if you are going to prevail on the view that the trustee's right is a proprietary right over the fund, you have, I think, come up with some explanation of why a distribution to a beneficiary out of a solvent fund takes free of it. And if it's not because it's a floating charge, and I can see the difficulties of that, I'm just casting around in the dark for what other mechanism works.
Yeah, no, I do understand the question. It's but how should I put it? 40 years experience of dealing with re-Diplock style cases makes me sufficiently aware it's actually a very difficult question.
Yeah, sure.
Yeah. Mr. Torp, if we were to give you 14 days to put in your written submissions, would that be adequate?
Thank you very much.
And in that case, so we ask Ms. Warwick-Smith, Ms. Stanley, and Mr. Mitchell if they wish to supplement the replies that we're about to hear, and to put those in within 7 days thereafter.
Thank you, my lord. That would suit us very well.
Yes, my lord.
Very well. I'm sorry we've had to adopt these certs, but I've never known a hearing that's been as plagued with problems as this one has been. So, so we turn then to you, Ms. Warwick-Smith.
Thank you, my lord. And I will just briefly, if I may, outline what we would have said in a slightly lengthier reply, and
yes,
then, as you suggest, supplement that. As a matter of formality, of course, what I'm really replying to is the Jersey respondents' submissions, but because we have adopted some of Mr. Mitchell's submissions, particularly in relation to priority, in fact, I'm also replying to those issues in relation to Mr. Taub's submission. So it is all slightly mixed together. Mr. Taub has also made certain observations about the Jersey proceedings to which we would inevitably want to reply. So it's not as if these two appeals are completely being dealt with completely separately. The first overarching point I really want to make is that, and it's a very obvious one, but it perhaps brings it back home, and that is we are, of course, talking about Jersey law. And it is very interesting, of course, to read the acres of print which we've considered over the last few days, and to hear submissions from my colleagues. But we are talking about Jersey law, and we do know that Jersey law is in certain important respects different from the law of England and Wales, the law of Australia, the law of other jurisdictions which have considered these matters. And it is vital in our submission to bear that in mind. One of the most important aspects of the difference between the various jurisdictions is that the Jersey court is not a court of equity in the sense that it is known in England and Wales, but it is a court of equité. And we have cited in our supplemental references that we lodged yesterday when we ran short of time to complete our submissions, references to that jurisdiction, and we can make those points again in writing if we need to. The concept of equité, as we know, is a somewhat wider concept than that of equity, in the sense that it does connote fairness. It mitigates the rigour of settled principle. And that is an important cornerstone of the way in which Jersey exercises its jurisdiction in this area as much as any other area. The second general point is that what is very striking about the survey of cases that we have looked at over these last few days, and some that we haven't looked at, is the wide variety of circumstances in which the various courts have considered the nature of this right. Many of them, in fact all of them, highly fact specific and arising in circumstances which are maybe, and indeed are mostly, very different from the circumstances which we are considering in this case. So a cautionary note, it seems to us, with respect, is necessary in relation to what is said in those cases, because most of them really are a reaction of equity courts to particular circumstances. They are, how do you recognise the various competing interests of right? Many of them don't concern, of course, the rights between existing trustees and subsequent trustees at all, and so they don't inform particularly that debate. So while interesting, it's fundamental to appreciate that those very fact-specific cases and the observations that are made about them may simply not shed much light on the matters before the board. Now, surveying really the territory over the last 3 days and the debates that have been conducted, and trying to stand back now for a moment and look at it from a Jersey law perspective, what we respectfully suggest to the board as a possible approach to these matters is as follows. And that is that we call the right by its name. That is, that it is a right of trustee indemnity. It is not helpful, as I think everybody agrees, to adopt the varying terminology that has been adopted in the cases charged, liens, and so on. The fundamental right is a right of indemnity. And the challenge is to identify the attribute in practical application of such a right. And what we suggest is the following, and we can put this in writing rather than asking the panel to take a note at this late stage in the day. But we suggest that the attributes of that right of indemnity are as follows. First of all, it gives a trustee who incurs reasonable liabilities as trustee a right to pay them out of the trust fund, whether directly or by way of reimbursement, as and when needed. That is uncontroversial, I think. Secondly, reimbursement as a matter of Jersey law of those reasonable expenses is a statutory right. It arises under Article 26(2). So we needn't look further than the Jersey statute in relation to the right of trustees to do that. Thirdly, it's a right which is superior to the interests of beneficiaries to avoid unjust enrichment. Size of the trust fund will fluctuate accordingly. That is to say, as and when liabilities arise and are either discharged or reimbursement is sought in relation to them, the beneficiary's right will vary according to those circumstances. Fourthly, and this is really crucial to an understanding of how the right works, is that the right is not, in our respectful submission, and there is no real support in favour of the proposition, that the right is a full-scale, equitable, proprietary interest. What it is, we respectfully suggest, is akin to a mere equity. And of course, the panel will immediately recognise the distinction between equitable interests, full-scale equitable interests, good against all the world except equity's darling, and on the other hand, mere equity. What it is a right, is an inchoate right of trustees to have their right of indemnity recognised. And so while it prevails over beneficiaries, who are, of course, in an insolvency situation irrelevant, because what you effectively have is a bare trust in favour of creditors, what you don't get out of the authorities and cannot elevate out of what is said about the right is a full-scale proprietary right. A mere equity is a right to perform, to be able to perform some further act to cause a claim to crystallise. In this case, to make a claim under the indemnity or to go to court to seek to vindicate that claim. And in support of that proposition, we refer you and will refer you to, in writing, Pumphrey, which is at page 2352 of the Jersey Bundle, and of course also the famous definition of a mere equity as being naked and alone by Lord Upjohn in National Provincial Bank and Ainsworth. This is much closer to something which is properly described as a mere equity and not an equitable proprietary interest. We will also refer you to, in writing, as we have already, I think have done in our additional references, to the article in the Jersey and Guernsey Law Review by the former bailiff, Sir Michael Burt, very distinguished jurist in his own right, who identifies the consequences of elevating what is really an equity of this kind, an equity to be reimbursed or an equity to be indemnified, into some kind of full-scale equitable beneficial interest or security interest. Fifth proposition is that when a trustee is incumbent, who holds the trust fund and is in office, the trustee has trust law powers it can exercise. It's got all the trial powers under the trust. It's got all the powers that it has under the Trust Jersey law and any implied powers that the law otherwise gives the trustee. And it has actual control over the trust fund. No issue arises when the trust is sufficient to meet assets. Third-party creditors are subrogated to the trustee's indemnity if they need to enforce their security, and they can force the trustee to exercise that right of indemnity in their favour, or they can go to court to seek enforcement of that right. Sixthly, when the trustee ceases to be a trustee, it loses its trust law powers, and that's perhaps the most important point of all in some ways. It loses its trust law powers, and I took you to the provision of the Jersey Trust Law, which says, you might think completely self-evidently, that when a trustee retires, it ceases to be the trustee. One would have thought blindingly obvious, but the consequence of that one spells out from that very obvious statement of principle is that, of course, the trustee no longer has powers over the trust fund that it can exercise as it has before. But it does not lose its right to be indemnified against liabilities which have been properly incurred in relation to actions taken while it was a trustee. Unless, of course, there was some express agreement to the contrary, but it seems unlikely that in most circumstances that would happen. So there is no question that the right of indemnity continues after a trustee, ordinarily anyway, continues after a trustee ceases to be a trustee. This is not a case about a cessation of a right to be indemnified, although it is partially a case about how that right is vindicated. And of course, part of our case is that what happened in this case was that the trustee contracted with the incoming trustee, and that contract, the DORA, regulates the relationship of the parties going forward. And I'll come back, if I may, to that point. But the way, this is my seventh proposition, the way in which a former trustee asserts its right is either A, by claiming on express indemnities given by replacement trustees under ADORA, which then leaves the new trustee to indemnify themselves or seek indemnity out of the trust fund to reimburse itself in relation to satisfaction of that contractual indemnity. Or secondly, or B, where there are no express indemnities, claiming by way of subrogation to the incumbent trustee's right of indemnity, and again asking the court to intervene as necessary. So that what one gets in an ordinary case, and as a matter of general principle, is what might be regarded as double subrogation. In other words, a creditor of trustee number one, who is subrogated trustee number one's right of indemnity, is subject to the state of account between that trustee and the trust, so that if the trustee owes the trust money, the creditor is prejudicially affected by that, but that's simply a fact of subrogation life. And then the former trustee claims over against the second trustee in relation to those creditors. And again, there's a second layer, as it were, of subrogation, depending on the state of account between the parties. Now, part of the debate in Jersey and elsewhere has been, and you will see in the papers, and we've given references to them, the consultation papers that have variously been issued by the Jersey government over the years, considering the rights of creditors against trust funds. And that's been the subject of consideration in the UK as well, that we are dealing with Jersey law. There's an ongoing debate about whether that is the best form of protection or an appropriate form of protection for creditors. But nevertheless, it is a fact of subrogation life. That's the way it works. Lastly, the right of indemnity of an incumbent trustee and a former trustee is of the same nature. They may not share the same lien, but it's of exactly the same nature. They both have right of indemnity out of the trust fund for proper liabilities reasonably incurred. Now, when looked at through that prism, there is absolutely no reason why creditors, including the trustees themselves, and creditors claiming through them, should not rank pari passu. There is no difference in the nature of the right of a former trustee and an incumbent trustee. The alleged priority of a former trustee, which is clung to by the respondents, depends wholly on being able to establish this supposed equitable proprietary right, which we say has no support at all. What the trustees have variously, and it applies to any number of successive trustees, is a plain right of indemnity out of the trust fund. And when it comes to a distribution of insufficient assets to satisfy everybody's liability, well, then everybody dives in and gets the same treatment, as it were. So that's the sort of outline of where we say matters stand. That is to say, it's a very straightforward, surprisingly, after this very detailed examination of how it works, how it does work, we say, and how it's supposed to work in practice. And again, it's evident from some of the writings, the contemporaneous writings at the time of the DORA, that that was how it was supposed in practice to work. We see in Jersey constant questioning of whether it recognized something like a non-possessory lien over assets. We've seen from what we've seen of Jersey customary law that it's plain that Jersey did not recognize a non-possessory lien and still does not, notwithstanding that it's signaled its intention to introduce such an animal in the same way as Guernsey had, although not necessarily in exactly the same form. But that is a matter best left to the legislature, because that involves policy considerations taking into account local circumstances, what is thought to be best for the financial services sector, of which the trust sector is a significant part in Jersey, and not with respect for the court to impose. That is the way in which what was said in Investec and Glenalla has been characterised locally in Jersey, that what it amounts to essentially is a security interest that simply cannot be recognised. We know that in Jersey, only security interests of the type prescribed first in the 1983 Act and then in the 2012 Act can be recognised. This was a resignation and a DORA which took place in 2006, well before the 2012 Act came into effect, and that Act simply does not apply either in these circumstances or to the type of the right that was supposedly identified in Investec and Glenalla. Now, we can support those propositions by reference to such authority as they are, and we will do that in writing, such as the shortage of time now. But in relation to the DORA, again, both a theoretical and a practical point. It is quite plain that a DORA, properly expressed and absent any express reservation of rights, replaces any statutory right or common law right or equitable right, whatever it is, that is intended by the parties to replace and to some extent replicate the rights that a former trustee had under however the right arises. The detailed provisions of the DORA in this case, negotiated in 2006, at a time when non-possessory liens were not recognised in Jersey quite plainly, contains very detailed provisions to which I took the panel at the beginning, including a clear acknowledgement that sufficient security had been given to the previous trustee, including, and that security included, the giving of contractual indemnity. Now, what is often said about contractual indemnities is, oh, they're just contractual indemnity, as if the form in which they're produced is somehow determinative of the status which they occupy. But of course, to say that those rights are contained in a contractual document doesn't tell you anything about their force and effect. And what we say about the force and effect is it plainly is intended to, in most cases, unless there's some agreement to the contrary, replace whatever rights and protect a previous trustee in the way set out in the DORA. Otherwise, trusts simply don't work. And again, Sir Michael Burt adverts to the consequences of not recognising that principle. Now, I fear that I've already exceeded my 20, or just coming up to my 25 minutes time, and that is simply a very general outline of what we would have said in somewhat more detail. We also have some specific points to correct, we would say, in submissions made by Ms. Jordan and Mr. Daub, but again, we can identify those in writing.
Yes, very well then. Thank you, Ms. Warwick-Smith. We better turn then, I'm afraid, with very little time left, to Mr. Machell.
Well, my lord, what I was going to say is I rather suspect my reply submissions may carry more force if I put them all in writing rather than trouble you with my ramblings in the last 5 minutes. So I'm content just to put my reply submissions in writing. So if there's anything else that Miss Warnock-Smith would like to say, then I'm more than happy to cede her my 5 minutes, or we can break 5 minutes early, my lord.
Yes, well, perhaps we might see first of all if any of the members of the bench have points they wish to put to you.
Mr. Machell, you are going to put your submissions in writing, so there's no need to reply to this at all at this point. But if anyone else, including yourself, wishes to reply on the meaning of Article 32 and the concept of a right against trust property being given to the creditors, I should be grateful.
We will do that, my lady, for sure.
That applies to Mrs. Warnock-Smith as well, of course. And Mr. Advocate Jordan.
Yes. Speaking for myself, I've found probably the most interesting authority we've looked at to be the Amarind case. But in that case, a lot of weight is being placed on the joint judgment of Justices Bell, Nettles, and Gagler. They do adopt a different approach to the issue that we're particularly concerned with from Chief Justice Keyfall and Justice Edelman and Justice Keane. And I'd be quite interested to know what, if people wish to make any submissions on the difference in approach and why one approach should be preferred to the other.
Sure, we would certainly be grateful to have an opportunity to respond.
Yes, I mean, there are a variety of views expressed, for example, as to whether what they were dealing with, was a fixed security or something analogous to a floating charge. And Lord Briggs.
I would welcome anything anybody wants to say in writing about the mere equity submission, which we heard a few moments ago, both in terms of whether it is a mere equity, but then if it is, what the consequences are in terms of priority between the mere equity of two successive trustees.
My Lord, I'm grateful for that indication, and that was something I was going to seek leave from the panel to respond to on our behalf, the point about mere equity and the consequences of that. So if the panel are in agreement, we would ask to put some written submissions in. And I'm conscious you're going to receive now written submissions from everybody. So I'm sorry, but I think it would be of assistance if we could answer that mere equity point, because that is slightly different to the case that was put on Tuesday.
Yes. Well, Ms. Jordan, in that case, can you also do that within 14 days?
Yes, of course.
That'll give those who are putting in replies an opportunity to respond to anything you might say.
I'm grateful. Thank you, my Lord.
Very well. Well, if there are no further questions from the board at this time, then I think we can draw the hearing to a close. Can I thank all counsel and those who have assisted them in preparing the cases and submissions, which we found most helpful. And after we've received your final submissions in writing, we'll endeavour to reach a conclusion on these very difficult questions and tender our advice in due course to Her Majesty. Can I finally just say how sorry I am to all counsel. I appreciate how disruptive the technical problems that we've had must have been for you. Thank you for your patience. These have been exceptional, and we'll try to do what we can to avoid them recurring in future. In the meantime, the board will adjourn.